Hello and welcome to another edition of Immigration Nation. My name is Nicole Whitaker. I'm an immigration lawyer in Towson, Maryland. And today we're going to be talking about how to get a green card for someone who is under 21 years old. So, who is this video for? This video is for you if you are under 21 years old and you need a green card, or if you are caring for someone who is under 21. Maybe they're your son or daughter, or maybe it's a family member or a friend that you are taking care of, and they're under 21 years old or under 18 in some states. We'll talk about that. But either way, this person needs a work permit and a green card. We're going to talk about the Special Immigrant Juvenile program and how this program helps people under 21 or under 18 in some states get a work permit and green card. So again, my name is Nicole Whitaker. I'm an immigration lawyer in Towson, Maryland. And although my physical office location is in Towson, Maryland, we represent clients all over the country. If you would like to schedule your consultation directly with me, give us a call at 410-207-9272. Everyone in our office speaks Spanish, and if you call, you'll schedule a consultation to have your 1-hour appointment with me to ask all of your questions. And if we're able to help you, I'll tell you all about your options and how much it will cost, how long it will take, and everything else you need to know about your immigration case. So before we get started, thank you guys for subscribing to our page. Thank you for liking this video. Thank you for sharing this video with your friends and family. Thank you for sharing our page with your friends and family. We appreciate all of your support, and I hope that this information is helpful to you and to your friends. So today, again, we're talking about how to apply for a green card if you are 21 years old. This video is for you if you are under 21 years old, or if you are caring for someone who is under 21 years old. It might be your own son or daughter, or it might be a family member or friend that you've taken in that you are caring for. So, what is Special Immigrant Juvenile Status? Special Immigrant Juvenile Status is a way to get a work permit and a green card for people under 21 or under 18 in certain states if they have been neglected, abandoned, or abused by one or both of their biological parents. So let's talk about each one of those scenarios in a little bit more detail. Again, I'll repeat the definition. It's for individuals under 21 or under 18 in some states who have been neglected, abandoned, or abused by one or both of their biological parents. So in a lot of my cases, my clients have been just abandoned by one or both of their parents. Sometimes it happens early in the child's life. Maybe there's a mother or father who just doesn't want to be involved, and they were never a part of the child's life, or they were there when they were a baby, but then they lost contact and they're no longer in that child's life. That is an example of abandonment. And if you are living with that child, maybe you're the other biological parent, or your friend or family member caring for a child that was abandoned by one of their biological parents, you can help them get a work permit and a green card through the Special Immigrant Juvenile program. What about abuse? Obviously, if a child has been abused before they were 18, maybe their parents were physically abusive or emotionally abusive. Maybe they were abusive to another parent and subjected the child to witnessing that abusive behavior. That is abuse. Something else that is considered abuse or neglect is having your child work at a young age, or forcing your child to quit school, or not providing for your child enough to attend school. In a lot of other countries, the children are raised differently than they are here in America. And for the Special Immigrant Juvenile Program, the definition of neglect, abandonment, or abuse is based on what is considered abandonment, neglect, and abuse here in the United States, not in another country. So even if it's normal for a child to go to work at 13, 14, 15 years old in their home country, it is not acceptable here in the US. And so, and the same thing for attending school. In some countries, it's normal and socially acceptable for a child to quit school at 6th grade, 7th grade, or 8th grade. In the US, it's not. So if your child had to stop school when they were younger, or they had to go to work to help support the family in their home country, those things might be considered neglect or abuse for the purposes of the Special Immigrant Juvenile Status Program. Other forms of neglect might be where the child doesn't have enough food or water. Maybe they don't have clothes or shoes. Maybe they lived in a bad situation where it wasn't clean. They didn't have like sanitary conditions with modern plumbing. And because of that, the child was at risk of getting sick. So those are examples of neglect. Again, the standard is based on the American standard of an adequate care of a child. So again, my name is Nicole Whitaker. I'm an immigration lawyer in Towson, Maryland. We are talking about the Special Immigrant Juvenile Program, how to get a green card for young adults under 21 or under 18 in some states. So if you have questions about this, please leave your questions in the comments below, and I will answer your questions as they come up. So we talked about the definition of Special Immigrant Juvenile Status. This program is for individuals under 21 years old or under 18 in certain states who have been neglected, abandoned, or abused by one or both of their biological parents and now live in the United States. Another common type of case that I see with my clients from Central America, clients from Guatemala, El Salvador, and Honduras, is children being sent to the United States to live with their other parents, a friend, a family member, maybe an older brother or sister or an aunt or uncle. And in those cases, children are generally being sent to the US because they are fleeing violence in their home country. They're fleeing gang violence, they're fleeing general violence or the threat of being recruited by a gang. In those cases, their parents love them and they know they cannot protect them in their home countries. And that's why they're sending them to the United States. But for the purposes of immigration, for legal purposes, we consider that abandonment. If that's your situation or the situation of a child you're caring for, they may be eligible for a green card and a work permit because they were technically by law abandoned by their parents, right? Their parents sent them to the US unaccompanied without anyone else, crossing multiple international borders to come live here in the US with someone else. That parent doesn't have typically a visa or any way to get a green card and come live permanently in the US. Instead, they sent just their child to come live in the US to protect them. Regardless of the parents' motives, the fact that they love their child for legal purposes, for the purposes of immigration law, that child is eligible for a work permit and green card based on special immigrant juvenile status because they've been abandoned by that parent who sent them here in the US. So let's talk about one of my cases from a different country, not Central America. Let's talk about a client that I had from Africa. So I had a client, a teenager from Africa. Her case was similar to the case from Central America, where a parent is sending their child to the US unaccompanied to live with family members because the parent could no longer take care of them. In this case, one of the children's parents had passed away in a tragic accident, and the other parent just became no longer able to care for her children. And she wasn't able to pay for private school, which is important in this place, in this country where they come from, where public schools are very dangerous. They weren't taking the children out to get food and clothes, and certainly not taking them to school. So the children were just like stuck in the house. They were kind of taking care of themselves because their mother had gone into a deep depression. But she had family members here in the US, and she sent her children to the US to live with different people, just because she was no longer able to care for them herself. And in that case, all of the children were eligible for a green card through Special Immigrant Juvenile status, based on the fact that their mother had abandoned them by sending them to the US to live with other people. So if you are taking care of someone who is under 21 years old or under 18 in some states, you can help them get a work permit and a green card by applying for Special Immigrant Juvenile status. If you'd like to schedule a consultation to talk about your case specifically, you can give me a call at 410-207-9272. If you have questions about this program, leave them in the comments below. I'm going to talk a little bit about some of the common questions I get about this type of case. But before that, I'd like to thank you for all of the likes. Thank you for sharing this video. If you think your friends or family could benefit from this information, please share this video so more people can get this information. So, frequently asked questions. What are some questions that that I normally get asked about Special Immigrant Juvenile status? So first of all, when we're applying for Special Immigrant Juvenile status, someone has to petition a state family court for custody or guardianship of the child. And that's where the 18 or 21 years old rule comes in, because it depends on what state you're in, whether the family court will allow children who are over 18 but still under 21 to get an order for the purposes of Special Immigrant Juvenile status. So for example, Maryland and New York are states where children can apply for Special Immigrant Juvenile status when they're 18, 19, and 20 years old. But in all states, you can get Special Immigrant Juvenile status if you're under 18. But specifically, if you're in Maryland, New York, and a couple other states, you are able to apply for Special Immigrant Juvenile status until you turn 21 years old. So some questions I get asked a lot is who can be the petitioner or the custodian, the person petitioning the court for custody or guardianship of the child. Ideally, it would be the other biological parent. If you are the biological parent and your child has been abandoned, neglected, or abused by their biological mother or father, you'd be the person petitioning the court for custody. If you are that child's close family member, ideally, courts like to see that the children are still in the care and custody of close family members, older close family members. In some cases where there really is no other adequate adult, a close and trusted family friend can be the person petitioning the court for custody or guardianship of the child. Another question I get a lot is whether the child has to remain in school. If you stop going to school, or if you never enrolled in public school here in the US, can you still apply for special immigrant juvenile status? The answer is yes, you can still get special immigrant juvenile status if you stop going to school or if you do not graduate. Obviously, if you can stay in school, it is so important for your future in the country to stay in school, to get a high school diploma, or at least a GED if you have no other options. In this country, education is so important, and getting a high school diploma really is like a minimum requirement for so many jobs and so many opportunities you might have in the future. It's really important that you go to school and graduate. But with that being said, I know in some cases it's people can't go to school anymore. They quit school, and the truth is that you are still able to apply for a green card and work permit through special immigrant juvenile status, even if you're not going to school, even if you don't graduate, even if you don't get a high school diploma or a GED. But my recommendation is to continue going to school and get your diploma. It's just so important, and it will unlock so many doors for you that will be closed if you don't get that high school diploma. Another question I get a lot is what about, or what happens if the person petitioning the court, the adult petitioning the court for custody or guardianship, what if they do not have legal immigration status? What if they are illegal or undocumented? I cannot speak to every state in the country, but at least in the state of Maryland, it typically is not an issue, and typically there's very little to no risk for that individual petitioning the court for your guardianship or custody. In, I believe, all of my cases for special immigrant juvenile status, they're uncontested. That question of immigration status doesn't even come up. It's nowhere in the legal pleadings, the documents that we give to the court. I don't ask about it in court. The judge doesn't ask about it in court. It doesn't come up, and it's not an issue. But that varies state by state, and that's something that you should talk to your lawyer about if you want to file for special immigrant juvenile status. Again, my name is Nicole Whitaker. I'm an immigration lawyer in Towson, Maryland. And although our physical office is located in Towson, Maryland, we represent clients all over the country with their immigration cases. We file for applications for green cards, for citizenship, and we help defend people in immigration court. Which brings me to my last point, which is that filing for special immigrant juvenile status can help you win a case in immigration court if you have a case in immigration court. Because the special immigrant juvenile program is a way to get a green card, it's also a way to defend yourself against deportation. And so if you are in deportation proceedings, or if you're caring for a child who's in deportation proceedings, you can file for special immigrant juvenile status as a way to not only get a work permit and green card for that child, but to win the case in immigration court. You can file this case even if you are under 21 years old and living in those certain states, and you have a child of your own. Some of my clients come to the US when they're pregnant, or they get pregnant when they're here in the US and now they have a baby. That is still permitted, and you can get a green card through the Special Immigrant Juvenile program, even if you have your own child. The only restriction is if you get married before you get the green card, you might be ineligible for the green card. So you can't get married. If you're already married, you can't get the visa juvenile, the Special Immigrant Juvenile status. You have to be single, under 21 or under 18 in certain states, and neglected, abandoned, or abused by one or both of your parents. And you have to prove that reunification with that one parent that neglected, abandoned, or abused you is not possible. So if you are under 21 years old, or if you're caring for someone who's under 21 years old, and you want to see if they are eligible for the Visa Juvenile or the Special Immigrant Juvenile Status Program, give us a call at 410-207-9272. You'll have a 1 hour long consultation directly with me. You can ask me all of your questions. I'll tell you about the immigration process, how long your case will take, and how much it will cost. Everyone on our team speaks English and Spanish, so if you think that you or someone you're caring for is eligible for Special Immigrant Juvenile status, give us a call today to start your case. We can't wait to help you get your work permit and green card.